All right. Hello, everybody. Thank you for joining us. I'm Gerard Simica, Chairman and General Counsel of CASE, Consumer Action for a Strong Economy. Today, we're here with a webinar with a great panel to talk about the future of electronic payments, specifically as it pertains to the Linney's Pizza versus Board of Governors of the Federal Reserve case now in front of the Sixth Circuit, an out uh, an outshot of the Durbin Amendment from the uh, Dodd-Frank economic overhaul legislation of 2010, which was supposed to be, of course, pro-consumer legislation that was going to reduce interchange fees and swipe fees from the evil banks and help consumers and merchants manage the costs of electronic payments. But it has been anything but. And our panelists will go into great detail about all of the false assumptions and the complete lack of understanding of the electronic payments ecosystem that has left us in this position, which is now in front of the courts as we look to determine what the uh, the government and Federal Reserve is going to allow banks to use for secure payments, electronic payments, which are now the prevalence for all consumers across almost any uh, goods or service uh, uh, market, which is so I think that we're going to start with see, we have as a quick introduction, Todd Zwicky, who is the GMU Foundation Professor of Law at George Mason University, Pete Sepp, who's the president of the National Taxpayers Union, Ben Sperry, the senior scholar for the International Center for Law and Economics, and Patrick M. Brenner, the president and CEO of the Southwest Public Policy Institute. So I think that we drew straws, and Ben, I think, is going to give us an overview of where we are today with this issue and with the case in particular. So this is start with a Ben, senior scholar, International Center for Law and Economics.
Yeah, thank you for the opportunity to be here today. As stated, I'm Ben Sperry. I'm a senior scholar and lead counsel at the International Center for Law and Economics. Scholars at ICLE have written a bunch of white papers and law journal articles, including a few with Professor Zwicky, as well as blog posts on issues surrounding the economics and regulation of interchange fees. In particular, I co-authored a brief on behalf of ICLE in the Sixth Circuit Court of Appeals in Linney's Pizza. The core conflict at issue in Linney is whether the text of the Durbin Amendment requires the Federal Reserve Board to set debit card interchange fees even lower than they've already chosen to do. More precisely, whether the interchange fee set by the board is, quote, reasonable proportional to the cost incurred by the issuer with respect to the transaction. This broad grant of authority does have two limitations. First, the board shall consider the incremental cost incurred by the issuer in the authorization, clearance, or settlement of a particular electronic debit transaction. And second, the board shall not consider other costs incurred by the issuer which are not specific to the particular electronic debit transaction. So the statutory debate has largely centered around whether the board was right to include a third set of costs, namely fixed authorization, clearance, and settlement costs, transaction monitoring costs, issue fraud losses, and network processing fees. But this case is not the first or the only one currently dealing with this issue. The DC Circuit previously found the Fed had the authority to include these costs when merchants brought the initial challenge many years ago, but they applied Chevron deference to get to that result. In a post-Loper-Bright world, it is now an open question, again, what is the best reading of the statute? A district court in the Eighth Circuit found in favor of the merchants challenging the Fed's reading in Corner Post. That case is now on appeal, and the Eighth Circuit has heard oral arguments. The district court in Linney's Pizza found in favor of the Federal Reserve Board, and oral arguments are now set in front of the Sixth Circuit for October 22nd. The big takeaway I want to put up front is, while this is pitched as a win for small businesses, forcing interchange fees lower would not only reshape administrative law and narrow the Fed's discretion, but ultimately make ordinary checking accounts more expensive for everyday consumers. To understand why this is the case, it's important to have at least a high-level understanding of the underlying economics. Payment card networks are multi-sided platforms. They have to attract multiple distinct groups, merchants and consumers. And in the case of networks like Visa and MasterCard, it's also important to consider the banks. As the Supreme Court recognized in Ohio versus American Express, the value of these types of platforms is based on the interdependence of each side. Card networks are more useful to merchants if more consumers use the card, and more useful to consumers if more merchants accept the card. Moreover, for four-party networks like those run by Visa and MasterCard, you also need to align the interests of the participating banks. This may oversimplify it slightly, but I trust that most people on this call have some background understanding. But basically, what's going on is networks historically charge the merchant side a higher price, in this case, interchange fees, to subsidize the consumer side. Debit card interchange fees funded consumer perks like debit card rewards, free checking accounts, and lower minimum balance requirements. And all of this changed after the passage of the Durbin Amendment and the promulgation of Regulation 2 by the Federal Reserve Board. Congress directed the Federal Reserve to cap the debit card interchange fees, requiring that they be reasonable proportional to the issuer's cost in transaction. The theory being that these high debit card interchange fees were being passed on to consumers as higher prices, and that by capping them, consumers would benefit through lower prices. In response, the Fed did cap those fees, but they included a range of transaction-specific costs like those I mentioned above. Nonetheless, the fees were set much lower than the going market price. The effects, well, they've been devastating for consumers. According to the Federal Reserve's own economists, when banks lost interchange revenue, they raised account fees, increased minimum balance requirements, slashed free checking, slashed and got rid of more or less debit card rewards. Who was hurt in particular were lower income households. This has also led to an increase, for instance, for unbanked consumers. Meanwhile, there's little evidence that merchants passed on their savings to consumers via cheaper retail prices. So that brings us to today. Linney's Pizza argues that the Durbin Amendment strictly limits the Fed to considering only the bare incremental costs of authorizing, clearing, and settling a transaction. They want all the extra costs the Fed has included in its formula to be thrown out. As mentioned previously, we now operate in a post-Chevron landscape. After the Supreme Court's Loper-Bright decision, the Fed won't receive Chevron deference. Nonetheless, Loper-Bright made clear that while courts must exercise independent legal judgment, Congress can still explicitly delegate policy-making discretion to agencies. Here, the delegation of the Fed to promulgate standards for determining whether an interchange fee is reasonable proportional to the cost incurred by an issuer is the type of broad grant of policy-making discretion Loper-Bright still allows. In other words, the statutory text supports the Fed. The Durbin Amendment tells the Fed to establish standards that are reasonable and proportional. It does not mathematically limit the Fed to purely incremental ACS costs. The argument is this avoids surplusage. If Congress wanted to set fees exactly equal to incremental ACS costs, they could have done so. But the phrase reasonable and proportional gives the Fed the exact type of discretion that's still recognized by the court in Loper-Bright. In our brief at ICLE, we argued that the Fed could have even went further and justified higher debit interchange fees in light of the underlying economics. A fee could be reasonable proportional, in other words, if it allows a bank to fund consumer benefits on the other side of the platform, like the free checking, the debit card rewards. And this makes sense. For something to be reasonable proportional in relation to cost, you have to take in consideration benefits. To judge consumer welfare accurately, the courts must look at both sides of the market. In sum, artificially capping debit interchange fees does not make consumer goods cheaper. It just shifts the financial burden back onto consumers through higher banking costs. Regulations 2's current cap is already much too low. Forcing it even lower, as Linney Pizza demands, will not result in, well, cheaper pizza. It will just result in more expensive checking accounts. There's no such thing as a free lunch, even when it's pizza.
And Ben, when you talked about the devastating effects, it wasn't just a matter of the banks just trying to make up for lost revenue and catch up, their balance sheets. The money that goes from the swipe fees was specifically directed and targeted, right, to fund um, free checking and lower balances and other services for consumers. So when they cut that, they were actually cutting the direct when they cut the fees, that was an actual pullback on these programs that the banks were funding, not for profit, but in order to get more people into the banking system. Could you mention that just a little bit as far as the direct fees funding these services for lower income bank customers?
Yeah, and I'm sure everybody in the panel can speak more to this in detail, but this is the nature of multi-sided markets, multi-sided platforms. Uh, Sometimes you give benefits to one side of the platform in order to get more people to use, well, debit cards or checking accounts with these banks. And that's exactly what was happening. And when those interchange fees dried up after the Durbin Amendment, a lot of those things started to disappear.
Exactly right. And part of it too, with the problem with the courts interpreting it, is we should mention, and I'm sure Todd and Patrick will jump on this too. Is just how the when the Dodd-Frank was being written and being debated, the Durbin Amendment was almost like a passenger running for the train to get on. It wasn't really debated. It wasn't really vetted. And Todd, did you maybe talk about how this thing even wound up as part of the overall final legislation?
Yeah, that's exactly right, Gerard, which is before the Durbin Amendment, there was a lot of grousing about this, but they had talked about relatively modest interventions like allowing merchants to collectively bargain for interchange fees so that they could try to get rates comparable to big box retailers, right? There's two ways in which rates traditionally are set. One is what they call interchange plus, and that's what the big retailers get, Home Depot, Walmart, and the like. So they benefit directly every time they can rent seek and use litigation and politics to reduce interchange fees. Their costs go down. Home Depot, in what their earnings call right after the Durbin Amendment was announced, estimated I think they were getting $35 million a year, I think it was, or $35 million just from the savings on the Durbin Amendment. No, they in no way represented that any of those savings would be passed on to consumers. And those on the call can tell me whether or not they've actually ever seen their prices go down at Home Depot or any of the other big department stores as a result of this. The answer is no, they have not. The other ones were ones that are not interchange plus, and this is what they were bargaining for, but these are just sort of a flat fee. And so one of the ironies of the Durbin Amendment was the floor also became the ceiling also became a floor, which is the big box retailers saw huge savings off of this, right? And they're the ones who are hiring all the lobbyists who are still pushing for this. But if you look at small merchants, saved very little as a result of this, and partly it's because they used to be able to negotiate with the card issuers, and the card issuers would give special deals to smaller merchants or people they wanted to get used to, encourage them to take cards and that sort of thing. Those breaks disappeared, and so what this has been is really just a massive redistribution from small merchants to big box retailers because small merchants haven't seen really much in the way of savings. And Ben outlined it perfectly, right? Which is this is a costly system. But here's the thing. Every payment system has cost. Every payment system has cost. Debit cards, credit cards, cash, checks, right? Tell me the last time you wrote a check. Tell anybody on the call, how often do you write checks at the store anymore? You don't. Why? Because a lot of merchants won't even take checks anymore because they're insecure, they're slow. You have to wait for payment, right? You have to wait, they might bounce. All these sorts of things. They're very costly mechanisms. A lot of merchants won't even take cash anymore. Why? Because it's costly to handle cash. You have to have a safe, and you have to hire armored trucks and that sort of thing. So what we've seen over the past decade or so, past 20 years, is merchants have basically invited consumers to use electronic payments like debit cards, right? They've said, come in here and do it. They've gotten rid of checks. They don't really want to take cash. These electronic payments literally saved the economy during COVID. And more people used it. And now what do we see? Basically, the merchants now, the story is simple here. The merchants benefited hugely from the uptake of electronic payments, and now they just don't want to pay for it, right? They just don't want to pay for it because, as we saw, that when the Durbin Amendment went into effect, rewards disappeared on debit cards, bank fees went up, they doubled, massive the amount of people who have free checking cut in half. And who are the ones who took it on the shorts the most? Low income, young consumers, minority consumers, right? Even guys like Robert Shapiro, the famous Democratic economist, who is one of the most outspoken supporters of the Durbin Amendment, now has recanted his support and said, nothing happened that I thought was going to happen. This has been terrible for minorities. This has been terrible for young people. It hasn't helped small merchants at all. And it's just been a massive redistribution to big box retailers, right? The leading economist who supported the Durbin Amendment has now recanted and come around to the light side of the force, just as everything has come about that we had predicted. The reality is simple, which is merchants gain more from taking electronic payments than they pay. Period. If they didn't, they wouldn't take them, right? They don't take checks anymore because the benefit of checks is too small relative to the cost. They don't take Bitcoin. They can avoid the cost of Bitcoin by not taking Bitcoin. They don't benefit. The cost of Bitcoin exceed this, right? That's all it is. Is all this is they want to get the benefits of this payment card network, and they just don't want to pay for the cost. They want to foist it off on us in the consumers. I'll say one last thing about this is there's all kind of unintended consequences from this, right? One of the first things is they did not index the Durbin Amendment, its $10 billion threshold, to inflation. So the number of banks now covered from the Durbin Amendment have gone from about 80 to 130 just because of inflation over the past few years. So more and more consumers are getting squeezed by this. The other things that happened is you've created a thriving ecosystem in sort of regulatory arbitrage. Now, fintech companies have saved the day on this, right? That the carnage would have been horrible, but for the fact that fintech companies have come along and come up with a business plan where they can partner with small community banks with under $10 billion in assets to continue to deliver free checking and the like to lower income consumers and the like. But that's it just creates an entire sort of workaround, an entire ecosystem. One of the things we point out in our brief is one interesting unintended consequence of that now is that non-Durbanized banks that are not that are under the $10 billion threshold, now we actually see the interchange fees they're charging is starting to creep up. And so a lot of these savings that were supposed to go through are actually are not going through. So it's created all kinds of distortions. It's been horrible for consumers. It's been horrible for competition. And if the merchants actually succeed in this attack in these litigation cases, it's going to be even worse. It'd be another huge slash. As you said, Gerard, the biggest thing that banks did was raise the mandatory minimum necessary to get free checking every month and eliminated all of the debit rewards. It went up about 5 times according to one of these things. They'll just continue to do that. At this point, the large banks have already said, I think it was JP Morgan Chase said after the Durbin Amendment, any consumer with less than $100,000 in assets is no longer profitable to us, right? And they sock people with fees. And this is going to go even further if we keep this up and they actually succeed in basically killing this. They'll basically be killing debit cards in America.
Yeah, just talking dollars and cents, and correct me if I'm wrong. So pre Durbin, post Durbin, we're looking at fees being cut roughly in half. Is that correct? What the merchants share of, and at
That's
the
right.
same
Yeah,
time, so they got if you wanted to say, well, these fees are outrageous and they're gouging merchants or whatever, 50% reduction is pretty good wherever you can
from
find it.
about 40 something cents to I think about 22
20,
cents.
yeah.
And it's
And so
estimated, I think it would be 7 cents under the North Dakota District Court ruling.
what Trainer want, and that was just I think a number he picked out of a hat
Right,
because he could count that high.
right.
But at the same time, too, we see retailers. How much more is it? $7 to $8 billion more revenue they're getting directly from this.
That's right. And
And
there's not a single study, any of the studies have been done, have not found anything resembling a significant pass-through by even in the most competitive markets like gasoline. There's been very minimal pass-through. Whereas I think the best studies we know about on the bank side, one Federal Reserve study found 90% of the revenue loss to the banks was passed through. Other ones usually find about 60 to 70%, right? Pretty much all of the loss to the banks has been passed through the consumers and higher fees, reduced rewards and things like that.
I just wanted to mention too, if we didn't earlier, the you can we have a question and answer period if you have would like to follow through. Um, you got any more of the points? cheaper that our panelists are making, and also you could raise it in chat if the button's not apparent. So if we wanted to just in 5 seconds explain this like I'm five, we cut the debit fees, the retailers are making a windfall, consumers are losing free checking, other banking services, foreign outside network ATM fees are coming back,
Right.
higher minimum standards, and no rewards whatsoever. I don't know anybody who there's any kind of benefits, rewards, or points that you get off
On debit
debit
cards.
anymore.
That's right.
So,
And lower income people are less likely to have credit cards, right? So you're basically
right.
taking rewards away from lower income people. And keep in mind, right? Again, there are costs here, right? What we're going back to is the system we had prior to universal access to debit cards, which is it around before debit cards came along, less than 10% of Americans had free checking accounts. Only the highest income people had. You had to maintain, pay your own monthly fee. You had to buy your own checks. Young people won't even, this will seem incomprehensible to them. You had to literally like fill out a form and mail order to get checks, right? And the like. And so what the banks want to do, or what the merchants want to do, is basically void stuff. And the only reason we had that was because of political intervention, which said that checks had to be cleared at par. So if you want to talk about what's reasonable and proportional, and one of the standards they say here is compared to what the costs are of checks. Costs of checks are really expensive. It's just that merchants managed to get laws passed that basically foisted all the cost of the checking account on consumers, even though merchants benefited from it as well.
And the merchants, whatever their swipe fees are always passed on to the consumer anyway. So we wonder when we have these cases, they're arguing in their briefs that they're being injured and damaged by the high fees, which they pass on anyway. And we've seen since they didn't lower prices for consumers when the fees came down. So there's a direct correlation. It almost makes total bunk out of their arguments that any kind of exchange fee, no matter how high it is injurious to their business.
And I'll just add, there was never any good reason in economics to think that the merchants were going to pass along a lot of these benefits or that they would pass them along very quickly. Like one of the theories is an idea called rockets and feathers, which is very well established, which is that merchants raise prices much faster than they reduce them after
Mm.
the fact, right? We're talking about tiny, tiny savings on each of these transactions add up to huge amount for a Walmart or a Costco, but are fractions of a penny or two in terms of savings for a consumer on a transaction. Things that small tend not to get passed on, whereas huge revenue losses, like the billions of dollars of revenue losses in one big chunk, like you described for the banks, those almost always get passed through. So we warned this is going to happen in a report that I co-authored for ICLE 10 years ago. We warned this was going to happen. Everything we warned has come to fruition, and I'm glad that Dr. Shapiro now has seen the light as well. So.
Yeah, this was the one area we had mentioned in our amicus that for some reason Senator Durbin believed in trickle down economics that that merchants would be so generous they would just give it back to their. Of course, it's quite different from Reagan's trickle down, which is instead of giving money to the government in the form of taxes, put it in your business so you can create a supply for demand. And but yeah, but for some reason he was all in favor of trickle down in that area. And Patrick, I think, has got some very interesting insights on the well on the markets themselves, but also on the incremental cost issue that the courts are looking at.
Sure. Well, I
Mhm.
guess let's focus on the incremental cost versus marginal cost question. But before I get into that, though, which was a core part of our brief, I got to give a shout out. I want to extend a very special thank you to Sarah Octoloni at the Brownstein Hyatt Farber Schreck firm for helping in SPPI's filing of our brief. But I wanted to focus the majority of my time here today on a single phrase because I believe it's one of the most important factors in the case. And that phrase is incremental cost. And to address it, I think we really just have to go back to Econ 101. At the corner post argument in the Eighth Circuit, the bench pressed pretty hard on the idea that incremental cost simply means marginal cost. If that's correct, the merchants win and the cap collapses towards zero. But we find that that is not correct, and our brief is pretty expansive in explaining why. Marginal cost and incremental cost are not synonymous. They are distinct terms of art, and the economics literature has always treated them as distinct. Marginal cost is the cost of the very next unit with everything else held in constant. Incremental cost is the change in that total cost. That is not our framing. That is William Baumol, one of the most cited economists in the entire field of regulated pricing. He wrote that in the Yale Journal on Regulation in 1994. Baumol defined incremental cost as total cost per additional unit produced. And he said explicitly that marginal cost and incremental cost can differ substantially. So we had later two management professors writing in the Accounting Review 20 years before that put it in 7 succinct words. Incremental cost is the change in total cost. So Congress had the word marginal available originally. They just chose not to use it. And we got to go back and look at what the statute actually says. It ties the costs to the role of the issuer in authorization, clearance, and settlement. The role, the function, not the derivative of the last swipe. So to explain this, I think I've worked up a pretty clever analogy. So here's how I would put it to somebody who doesn't work in this financial services space for a living. And let's use the plaintiff to do it. The marginal cost of one more slice of pizza off a pie that is already in the oven is really just a few cents of cheese. Okay. Nobody. Thank you for laughing, Todd. I appreciate that. Nobody believes a whole slice of pizza should cost just a few cents because the actual cost of the pizza being in the oven is, the actual cost of the pizza business is not just the pizza itself, but it's the oven, the dough, the driver, the insurance, and the person answering the phone for the orders. Linney's does not price a slice of pizza at the cost of just the cheese. Similarly, a bank cannot price a transaction at the cost of the electrons being sent over the communications network. So why is marginal reading not merely wrong, but absurd? And I want to give 3 reasons. First, the marginal cost of authorizing one more transaction on infrastructure that already exists is a fraction of a penny, which means that a marginal cost cap is functionally a cap of 0. Congress did not order a 9-month rulemaking, a nationwide survey of issuer costs, a reasonableness standard, and a separate fraud argument and fraud adjustment in order to just arrive at 0. Second, the reading destroys other parts of the same statute. The fraud prevention adjustments presupposes costs that are not marginal. The command that the fee be reasonable and proportional presupposes there is something to weigh. If the answer is simple arithmetic, there is nothing left to be reasonable about. Courts do not read statutes in a way that puts whole provisions out of work. Third, and this is the point I wish had landed more clearly at oral argument, no regulator anywhere sets rates at marginal cost in a network industry. It doesn't happen in telecommunications. It doesn't happen in electricity. It doesn't happen in pipelines. It doesn't happen in rail. Because in any business with large fixed costs and near 0 marginal costs, pricing at the margin guarantees the provider never recovers its investment. That is not a contested proposition. It is the first week of a regulated industry's course. So let's go back to college, everybody. The board already agrees with the economists too. In its 2023 rulemaking, the Federal Reserve stated that the costs at issue here fit the common economic definition of incremental cost. There are 4 of them. The fixed cost of processing a transaction, which includes network connectivity, software, hardware, equipment, and labor. Then there's transaction monitoring and an allowance for fraud losses and network processing fees. I think that Ben did a really good job of addressing that at the outset. Every one of those costs is incurred because transactions just happen. So if our brief makes one further argument, and if somebody reads only one section of it, this is the one I want to point them to. If you forbid a company from recovering costs that are real, that are specific to the transaction, and that it must incur to offer the service at all, you don't have a regulated price. You have taken property. So under the Supreme Court's Penn Central framework, a court weighs economic impact, investment-backed expectations, and the character of the government's action. All 3 point in the same direction here. Under today's cap, only 77% of issuers recover the full set of costs the board already allows. The merchant's reading drives that number down. The interchange system was built and capitalized long before anybody really contemplated a price control, and the character of the action is not a general adjustment of the burdens of economic life. It is the transfer of property from one identified class to another identified class. The Federal Circuit has seen this before. In Cienega Gardens, rent control imposed on federally subsidized housing was held to be a compensable taking because it indicated extraordinary economic harm and destroyed reasonable investment-backed expectations. A rent cap and an interchange cap are the same instrument pointed at different industries. So I'll toss it back to you, Gerard. Those are my thoughts. If you have any questions, let me know.
No, no, and well, it's very important too because when Congress wrote the law and they were trying to keep it flexible enough so that the Fed would have some framework in which to create the reasonable and proportional fee. That was one of the key terms in there is that it would be incremental. The categories they gave, some were discretionary, some were mandatory, but incremental was one of the real balancing words in there as far as what they could consider. And that is a crux of the argument from the two parties is which of these various costs, so sunk costs, the infrastructure costs, and the per transaction costs every time someone buys a pair of stocks, is it incremental or not? And that's where the courts seem to be really the two courts that are not in agreement on um, the viability of Reg 2. Is that how central is that, Patrick, would you say, to them resolving this? The very definition that you were espousing versus marginal.
I think it's entirely central to
You,
solving the problem. Yeah, absolutely.
As
what
Patrick said, this seemed to be of a particular point of focus in the Eighth Circuit's oral argument. But I believe it was last month. They were really pushing on what incremental costs meant and whether it could mean something other than marginal cost and the like. So I think in terms of the legal issue on the Eighth Circuit, at least, uh, having them correctly understand what the difference is, I think was very important to having the case resolved correctly.
and that Reg 2 doesn't really allow the banks to recover sunk costs, right? Anything that was um, part of the infrastructure, things like marketing, it's that go on with debit cards, those customer service, right? They're not even calculated, or are they in there somewhere?
I don't think so. Yeah, things like marketing, branches, right? Still, a lot of consumers open an account by going into to a branch, which is basically a version of marketing, right? Staffing branches, all those sorts of things were not considered relative to a particular transaction. So they've already excluded a lot of those costs, which is in itself, they're kind of making it very difficult for this to be in any way a profitable industry or profitable thing for a lot of banks to do, which is one of the reasons why they responded by, imposing new fees and all that sort of stuff on consumers who couldn't meet higher minimum balance requirements and the like. Because those costs were still there, they just couldn't recoup
Mhm.
them through even this version of the Durbin Amendment rule.
Before I wanted to talk to Pete a little bit about the politics of this, how something that has been so overwhelmingly is it's very difficult for anyone to defend this given the evidence, but yet they truck on. Going back to the takings issue, there was a challenge to Reg 2 back in 2011, and the court at that point uh, really much dismissed it on demur that these cases have to deal with monopolistic type of entities, like utilities, or it couldn't involve anything like a chattel, like a product like corn or cattle or things like that. So they said there wasn't part of the takings with a, a judicial body, but they now have it. There's been several rulings since then where takings have applied to things like cattle and non-monopolistic. And this court, even the Sixth Circuit, there was a required service a telephone had to provide, and they were not allowed to charge a certain amount for it. But the one case was kicked out. I think TCF National Bank was the one that was kicked out on demur. Do you think that this is open to anybody who wants to jump in, that it could be constitutionally challenged on the takings, with more of an expanded definition of what? Because what the gist is that they are not allowed to recoup their costs, and when you compel any business to provide a service where they cannot recoup their costs plus a fair profit, uh, that is kind of the definitions of this particular takings from the
I've
Fifth
been I've,
Amendment. So,
I've been involved in this so long. I actually wrote
uh,
an amicus brief in the TCF case, and
oh,
it's a fight that
go
never
ahead.
ends. But I do believe that the severity of what they're trying to impose at this point, it's just such an unreasonably small level, and so few costs could possibly be included. I think the optics for a takings case look, and we now actually know exactly what the consequences are going to be. Right at that point, the consequences were still somewhat speculative. Right, there are a lot of things in the air. So I think if this goes through, it'd be very ripe for a takings challenge, and I certainly would expect I would file an amicus brief in that case as well. So
Yeah, well, you guys have certainly round for getting your, under the hood of this issue to the rulemaking and the congressional language and the uh, all of the machinations the Fed went in putting this together. So it can be very a dry piece of public policy. But in the end, it's a very interesting issue just for your average consumer, because they're seeing how government bodies and courts, who are coming from it from different angles, are producing results that impacts them every day. And as we mentioned before, losing conveniences and services at banks, losing rewards and points and benefits that they got before. They wake up one day and go, "How come I'm not getting points?" Is, well, this wasn't on the news. This wasn't something anybody talked about. But so the question is that you have Linney's, which is probably represented by the big box retailers that are, making a killing off the lower fees. Um, they want to, I mean, I don't know what bank is going to continue to provide debit cards if they want to go down to 7 cents or even lower. They're, uh, sawing off the proverbial branch they're sitting on. But I guess they've just been, so lucky at the roulette table. They just want to keep going. So, Pete, where, with the impact on taxpayers and consumers, what happens if they um, prevail, and what options are there for a congressional fix? And why are we, they have made a lot of progress. Like, why are they still going at this with all the evidence so far that Durban's been a failure?
Well, Jerry, that was the primary reason of the brief that we filed. NTU's research arm, NTU Foundation, has a project called Taxpayer Defense Center, which focuses mainly on tax cases, but also on other public policy cases that can indirectly affect taxpayers. And the Linney's case is of special interest to us because NTU has worked on interchange issues all the way from the beginning when the Fed was making rules around debit cards. And, we learn a few things when we file an amicus brief. And one of the things is never to assume that judges are subject matter experts on the thing they're being asked to rule on. We run into that all the time with tax litigation, arcane issues like the supervisor approval requirement for IRS penalties, the economic substance doctrine, blah, blah, blah. Many people think, well, a judge has to be very highly read and very, very well vetted on the issue of public policy that comes before them. That's not always the case. In fact, that's not often the case. All of the briefs that we've talked about here are trying to fill information gaps that the deciding judges or judge, they need to know. And for us, that meant bringing up some of the consumer angles that we've heard about. What happens if debit cards go away? What happens if interchange limits get further imposed as a contagion in the credit card market, there's also a taxpayer angle here. The fact is, on the federal level, government issued payment cards get about $500 million worth of what are called spending-based refunds every year. That's the equivalent of rewards. Those accrue directly to taxpayers. Another big issue here is the private sector innovation of payment network security and how well that has affected the government ecosystem. Right now, SNAP benefits, what we used to call food stamps, are primarily administered at the state level using ancient payment networks. I mean, most of them are still using just the magnetic strips on the cards they issue for SNAP benefits. Some are only now getting into chips on cards. Now, if it's taking this much effort to get governments to think about common anti-fraud and security measures in the private sector, do we seriously believe that they ever would have thought of it on their own? No. So that's billions of dollars more that the concept of interchange has saved taxpayers. The other thing is we never assume the lawyers, even the ones on our side arguing the case, necessarily know every argument. Again, the quality of the legal counsel can be pretty good on the government side, or it can be terribly misinformed. They're just there because their boss told them to show up for the argument. And so here again, the purpose of amicus briefs can become very important in making sure the arguments that our own side should have made or should have made more forcefully end up getting made. And the third thing that our brief does and that our amicus briefs, I think, do in general is we never assume that anyone involved in these cases appreciates the overall policy context. We're thinking about this at the federal level, the federal government with legislation in Congress, the Federal Reserve. States are now dramatically, I think, intruding into an interstate commerce area where they can wreak tremendous havoc. I mean, our lobbying team at the state level has fought back against 20 proposals in 20 states so far to do interchange limits on credit cards and fool around with what's subject to interchange. You know, there are proposals now to say, okay, a tip left on a credit card at a restaurant no longer has an interchange fee applying to it. Those are the kinds of crazy proposals that we see creeping up in the states. And it's important for courts to appreciate that the decisions they make can have consequences there. And if you want to go really, really far down this road, and groups like ours have to, you begin to appreciate the overall impact on the size of government. Suppose we have very strict interchange price controls on credit cards. Airlines, many of them, have a bigger profit center in their affiliation agreement with cards than they do in transporting passengers. I mean, they make more money off cards than the people paying fares. And so what happens if that no longer becomes profitable or even sustainable? Airlines don't become profitable. Airlines start going out of business. Pressure builds for the federal government to either commit bailouts, take over air routes. Who knows? Postal banking. That could be another consequence. If there are not private card networks providing consumer credit, well, we'll let the post office do it. That's a serious proposal. I remember back in the 1990s, there were proposals to create something like Fannie Mae for consumer credit, a taxpayer-backed entity. They were going to call it Cindy Mae. I mean, can we imagine a world like this where something like a bad decision allowing super tight price controls on a well-functioning private payment facilitation network could result in things like this. It seems crazy, but really it isn't, especially in this political environment. I mean, look in the DSA's platform and you will see elements of price controls littered all over the economic component of that platform. So there's
It,
a lot at stake here.
one of the falsehoods that we've pushed back against is the need for this because there is, monopolistic bank control power in credit cards when it's actually a very competitive industry. That's why you have all these different rewards and these different programs that are expensive in order to, lure customers in. It's very costs a lot of money to get a customer, and then you have to hold on to them and keep them for a certain period of time. But what might you say to number one that the government has any place in this whatsoever, just because the banks need to be kept in check? And number two, if you were to say that if the best we could do was, say, light touch government regulation, would you be for a preemption where the states would not be able to, nibble on the margins?
Well, preemption is a power we've got to wield carefully. The laboratory of the states is an important policy incubator for things that we support. But as we were saying in preparation for this call, as far as interchange is concerned right now, the laboratory is producing nothing but Frankenstein monsters, trying to let them loose on consumers and taxpayers. There is going to have to be, I think, some kind of federal voice here that says, here's the lane that states travel in, but here's the lane that interstate commerce clause, whether dormant or otherwise, has to apply. And I think we're coming down to that for a number of issues. It really needs to happen here.
Yeah, Pete said something that's very important that I think is worth stressing, which is the importance of policy and explaining policy to judges who are generalists who don't understand this. These are really complex systems, right? Two-sided markets are really complex systems. They're not like walking into the grocery store, right? And Ben explained the two-sided market here, right? Which is a platform exists to link up merchants with consumers to maximize the total value. Now, there are a lot of characteristics of two-sided markets that are really important to understand because you ask about the role for government intervention generally, but government intervention is only appropriate where there's a market failure, and there's no market failure here. There
Right.
simply is no evidence of a market failure here. And for example, in two-sided markets, it's very common that one side of the market pays most of the cost and the other side of the market has either zero or negative cost, right? Another example is search engines, right? Should it be a world in which you have to pay a penny every time you do a search on Google because you're not paying for Google searches? The advertisers are paying every time you do a Google search. That's the logic here, right? Which
Yeah.
is I do a lot of searches but the advertisers still pay for searches where I don't do it, right? Two-sided a search engine. A newspaper is a two-sided market where advertisers subsidize readers, right? We see this all over the place, and this market is no different. It's very complicated. Trying to get the pricing right is not something you could do, as we've seen through central planning. And it's clear what makes no sense is this idea of basically foisting all the cost off on consumers to maintain bank accounts. So this really matters because if you read the North Dakota District Court opinion, the judge says he's just doing statutory interpretation, but littered throughout that are comments like the Durbin Amendment was enacted because interchange fees are going up so much and banks were reaping, record profits. There's no evidence that's the case, and we know that's not the case. How do we know that's not the case? Because as soon as these revenues were cut by politics, they ended up passing. They didn't just They didn't reduce their profits. They were forced by competition to force this to pass these on to consumers. So, he just sort of was opining like an op-ed or something with no basis. What would be the impact of this? Why this was passed? The banks were reaping record profits, and the reality is, what banks were doing were competing for customers by giving them better products at a lower price and driving financial inclusion of low-income minority and younger people on a scale that we've never seen in American history.
Yeah, and it's almost as if, whether by accident or design, I'm not a conspiracy theorist, bad public policy is what creates market failure, not market failure creating the need for public policy.
You see some even conservatives that have gotten on this bandwagon. I remember a couple of years ago watching Tucker Carlson when he was on Fox, uh, attacking the credit card companies for a 30% interest rate. And I just kept thinking, well, Tucker, just it's a great opportunity for you to introduce the Tucker card. 10%, you could, make it. They has no idea how this market works. The obviously they would, if they could take people with a very low credit score or small credit history, and give them 6%, that would be customers. They don't understand. The market's is going to fill that void, and you give again our senator in Missouri, Josh Hawley, is almost like Bernie Sanders on some of these banking issues. I don't know what the vendetta is, but there is no need for, as you said, the intervention. It's an extremely competitive market. We see that constantly with what's going on with community banks and local banks, and now they're fighting with crypto and other payment systems. But yes, whenever they intervene, it's not good news for consumers, and it doesn't lower prices or expand services for anybody. So
Yeah,
I,
they want to
I
call this a Wall Street versus Main Street type situation. But he's already said this is really big banks versus big box retailers because small merchants haven't benefited from this and probably won't. So it's basically Wall Street versus Wall Street, I guess, or big box retailers. What matters to me, I don't like big banks either. I've written a lot about debanking, their ESG practices, that sort of thing. I'm no big fan, but what I am a fan of is competition and consumer choice. And what I am is in favor of our markets that benefit consumers. And we have an unbelievably had a really slick, incredible system. When you think about a world in which you can go anywhere in the world 24 hours a day and make payments online, in person. I could walk out of here, go to the airport, go to Germany on vacation for a week, get back in a car, come back home, all without a penny in my pocket. And we're talking about a marvel of human technology. And Dick Durbin and these guys, they can just go in there and like tweak a few dials and that sort of thing and make it work better. And instead, what they're doing is blowing up the whole system.
And replacing it with postal banking.
Yeah.
So if these two, we have the sixth district, sixth circuit, and the A circuit that have currently on opposite ends of this, and they we might have completely mutually exclusive rulings on Reg 2. So does that mean, I think we'd mentioned it before, is it going to be decided by the Supreme Court?
Yeah, I think there's a good chance that the two courts end up differently. In fact, even if both courts end up the same, but it's against the Fed, I think there's a decent chance that the Supreme Court is going to take this up. It's just a scenario where if we're going to cut off the debit card system because the courts decide that they need to set the interchange fee even lower, there's only going to be bad outcomes, and the Supreme Court's going to want to speak to this.
And that's going to have to be on a national basis. You can't have Minnesota and Ohio having different regulatory regimes for payment cards like that.
It'll just be low in Delaware and Las Vegas. They'll just be what we have room for question and answers if anybody has wants to follow up on some of these points. And I don't know where
Should they put
Congress right
questions in
now.
the chat?
Yeah.
Is that the best spot from?
Sure. You can raise their hand, or they can
Okay.
post it in the chat. And I think we've done such a thorough job of covering all the angles that I don't have any questions right now, so
I see
um,
John Burlau had his hand up.
oh, you did? Okay.
Up now it's back down.
Let's see.
Now it's back up. John,
Hey, John. He mentioned his name.
do you need to be able to turn on his mic or something?
We
Um,
all have his number. Just call him.
yeah. Well, there's a chat in here where it can be typed in, but maybe is see, I could mute him. Participants.
I
There he
think
is.
John and CEI filed their own
Awesome.
I'm unmuted now.
amicus.
Can you hear me?
Yay!
We can, John.
Okay. Yes, we did. We did in corner post, and that was and we made I have been there was an earlier case. In fact, if you guys could talk about the earlier case, Judge Richard Leon in the Virginia, well, the federal district that includes Virginia that was overturned where it was on incremental costs as well. And basically I pointed out at the time what Patrick was saying about and the great points he made about what economists like Baumol have said about incremental costs, and that was part of the ruling there. And so I'm just and then we filed an amicus in the corner post case. Now I'm wondering what is happening with the corner post case. I guess you mentioned the conflict in the conflict among the circuits now, and so are we awaiting both decisions? And what had happened as far as the why didn't the earlier decision on this? I guess the answer is because it's in one circuit. Settle this matter.
Yeah, so they just recently heard, so the uh, District of North Dakota, we talked a lot about that opinion. The judge held that the Fed had abused its authority. I think it was under the Administrative Procedure Act that they departed from the statute too much, and so nullified the regulation. There's another regulation that's kind of sitting out there as well. Maybe that was the one you're referring to. That there was a revamp, a new version of the price control regulation that was proposed during the Biden administration, and that I don't know where that is in the litigation process. So we're still litigating the 2011 rule here, and it was able to be challenged now because it's been noted the original ruling in 2012 was upheld by the DC Circuit using Chevron, but following Loper Bright now, there's an irony now, which is the combination of Loper Bright and corner post from the Supreme Court basically means every single regulation now that has ever been written and it's not been but it's not been upheld by the Supreme Court can potentially now be challenged in federal court. So I don't know if John Roberts has any idea what avalanche he has opened up, but what we see here is sort of the problem, which is and the absurdity of the North Dakota judge's ruling, which is the North Dakota judge appropriately makes fun of how incoherent the Durbin Amendment is. It makes no grammatical sense. The terms aren't defined, right? He says these words are just randomly interspersed, yet somehow he decides that the language is unambiguous and he knows exactly what it is. That's
and
kind of
and
the
and
issue.
that's where I think Patrick and what we and us and others as far as pointing out incremental cost, because the judge, I mean, just basically used it's like Black's Law's dictionary for a definition of
Right,
incremental cost, or said it was the same, just gave really short shrift to that. And
right.
if he had known or been better briefed on what it was in the initial trial, I think he might have gone the other way.
Could have been, and the Kentucky court, the Linney's Pizza case was heard in the District Court of Kentucky, and the judge there did an excellent job. I mean, he started obviously with the same proposition. It's a very poorly written statute with a lot of technical terms, as you said, and to kind of cut to the chase, it looks exactly like the kind of statute in which Congress is basically telling the Fed, use your expertise to figure out how to make sense out of this mess that we're throwing on your desk, right? And so the Linney's Pizza case in Kentucky had a much more I think, sensible approach to it, which is this is a statute. It's poorly written. The terms are technical. You can't just look at Black's Law Dictionary. This is why we have regulatory agencies, and we can determine that Congress had wanted the Fed to implement this, right? And so that's the case that's gone up on the Sixth Circuit. I believe it's going to be argued October 22nd, I think I just heard recently. So, and the Eighth Circuit case has already been argued a couple weeks ago. You can find the oral argument on the Eighth Circuit's web page if you want to. So,
Thank you, and sorry about my technical difficulties.
Thanks for your hand up, John. Appreciate it. I don't know if anybody else. I've got the window. We're looking at our. Yes, no one appears to have a question right now. We'll be posting this and sending it around along with some a page of FAQs and some of the amicus briefs that have been filed, as well as some great articles that really break this down and from the economic sense of why is the government even um, toying in this area and just how disastrous it's been, and if they keep at it, we just get more of the same. So want to thank great panel for all stuff you guys have contributed along the way for both these cases in the Eighth District and the Sixth, and there'll be more coming our way in October, I suppose. And I don't know if there's any other active cases pertaining to exchanges, either at credit card, of course, is they keep trying to get the CCRA, the Credit Card Competition Act, which would do to credit cards what it's done to debit. And
the other cases to watch are
yeah.
the ones Pete referred to, which are these crazy laws by the states to determine politically what can and cannot be subject to interchange fees. And what we've seen already is what you'd predict is states are now they're just turning it into basically a political carnival, right? Which is taxes and tips here. Maybe it's something else there, right? The OCC has already announced that it's going to preempt those. We filed through ICLE a comment in support of preempting it on exactly that basis. But there was a case in Northern District of Illinois, and so that case is going along. Illinois, I think, maybe the only one who's actually finalized one of those rules, but other ones, Colorado had passed through the legislature, but the governor vetoed it. But we can expect more of those coming down the pike in future litigation on that.
Didn't Illinois extend the implementation deadline until July of next year?
The Illinois court?
Right, the Illinois Interchange Fee Prohibition Act.
Yeah,
they postponed the adoption date.
They postponed the adoption date, right, till everything gets sorted out. But
and arguably, it's been largely preempted at this point.
Yeah, but the merchants are, as you said, Jerry, are pushing on every single margin, right? And don't even get me started on what they're doing on surcharging, right? The dishonest surcharging transactions above cost, way above any reasonable cost. They don't disclose it. All these sorts of things. They're basically it's an all-out attack on the payment system politically, and all the litigation, everything they can do.
I'm not familiar with the state laws you're mentioning, but you said on tips, so you could pay for your meal with a debit card, but you couldn't put a tip on there?
You could put it on,
no,
but they couldn't charge
just that interchange. Right.
Yeah.
Sorry, go ahead, Todd.
Yeah.
They couldn't apply the interchange fee to the cost of the tip or the tax, only to the meal.
Okay, so the consumer doesn't know. Okay, I see. And then
Yeah. You could just imagine every state start carving up different things. You can imagine trying to keep all of this straight, right? Working the system in what it would require sort of technologically to adapt these things. And it's even crazier than that. Merchants could send in requests after the fact by hand to refund interchange fee on taxes and tips. I mean, it's a completely unworkable system and just another political attack.
So his final thought is you're now bringing the states into this magical gumbo of regulations and swipe fees, or is there going to be some federal legislation at some point that at least governs some foundational rules on, or do you think it's going to be determined by the courts and then the agencies?
If we let Congress play with this, we're going to get the CCRA well before we get decent rules surrounding this.
Yes,
And I wish it
it's a
were
good
the
point.
opposite, but we need a different Congress with a better
Mm,
collective brain before we're going to get those kinds of results.
Now, insofar as
point.
federal agencies can preempt, they've started some efforts towards that. The OCC, the NCUA, so they might take a role insofar as they can preempt when it comes to national banks or federal credit unions or what have you. But that doesn't actually protect everybody, but it would protect some of the major national players.
And it only works so long as the same party holds the White House.
Well, and it creates an uneven playing field too. So now you've got state institutions that are competing with an unfair playing field in which federal institutions are playing, and that's I don't think these state legislators realize that they're creating such a disproportionate effect on their own banking institutions.
Yeah, and ironically, it could be the case that even out of state banks could be in a better and more privileged position than the
Yeah.
state bank.
Well, who else is watching that did MiCA opt-outs?
It's going to be a big issue to follow to come. More webinars, amicus papers are on the way, it looks like. But yeah, I thought the ending might be a little bit more tidy, but when you bring up the states, it's going to be that's never a good thing. Uh, 50 different rules on where your debit card can be used. So, well, everyone,
Gerard, you
thank
got
you
to
for,
call it, or we're going to be here all afternoon.
yeah, yeah. So thank you everyone for watching, and we'll have the after party and on the Patreon. No, but appreciate it, and we'll follow up with our Linney's page and more news on how these court cases are decided. And thanks again for our panel and people tuning in, and appreciate your interest. And have a good one. Thanks,
Thanks for
everyone.
Gentlemen, thank
having
you very
us.
much.
Yeah.
You.